Hello everyone, welcome back to our channel. Today we will deal with a very famous French case, the La Poste case, dealing with the French Duty of Vigilance. First, we will discuss the premises of this law as well as its characteristic. Next, we will delve into the case of La Poste, which marked a turning point in the interpretation of the law and the duty of vigilance. Finally, we will look at the lessons and insight to be gained from this case. On February 11, 2015, a bill on the duty of vigilance of parent companies and contracting companies was registered with the presidency of the French National Assembly. For the group of parliamentarians introducing it, the reasons are clear. Economic actors must be held accountable in order to prevent human rights violation and environmental damage in the context of global economic trade. The collapse of the Rana Plaza building in Bangladesh in 2013, which killed more than 1,100 textile workers employed by European brands, revealed the hidden sides of globalized production chains, which are often opaque and efficiently monitored by those who place the orders. However, the legal separation between parent companies and subsidiaries often prevent the commissioning companies from being held liable for damage caused abroad. It is in this context that France adopted in March 2017 the law on the duty of vigilance of parent companies and contracting companies. This pioneering law aims to impose on large companies a genuine obligation to prevent serious human rights and environmental abuses resulting from their activities, including those of their subsidiaries and subcontractors abroad. Codified in Article L. 225, 102, and 4 of the Commercial Code. The law requires companies employing more than 5,000 employees in France or 10,000 worldwide to develop, publish, and implement an annual vigilance plan. This plan aims to identify, prevent, and mitigate serious violation of human rights and fundamental freedoms, the health and safety of individuals, and the environment. The plan must include 5 essential elements. A risk map prioritizing the most exposed areas and activities. Procedures for the regular assessment of business partners. Appropriate prevention and mitigation measures. A mechanism for alerting and collecting reports developed in consultation with the stakeholders. And finally, a system for monitoring and evaluating the effectiveness of measures. The law therefore imposed a duty of result on the company in formalizing the plan and a duty of means in its effective implementation. It is not limited to a simple reporting obligation. It establishes a new form of preventing responsibility based on transparency and diligence. To ensure the effectiveness of the system, the law provides for several enforcement tools. Any person with an interest in taking action may issue a formal notice to a company to comply with its obligations. If, after 3 months, no corrective measures have been taken, the matter may be referred to the courts to order the company to comply. In the event of damage, the company may be held civilly liable if its failure to exercise due diligence contributed to the damage suffered. Although this law showed promise when it was passed 7 years ago, the results remain mixed, despite inspiring several foreign and European initiatives. Its practical implementation has often been deemed merely formal. The first legal action, notably those against Total and Suez, focused on procedural issue, with no substantive case law to clarify the contours of reasonable vigilance. On December 5, 2023, the Paris Court of Justice handed down its first substantive ruling based on the law of 2017 on the duty of vigilance. The case pitted the Sud PTT union against La Poste, which was accused of failing to fulfill its duty of vigilance with regard to the human and environmental risk associated with its subsidiaries, suppliers, and subcontractors following the employment of undocumented workers by subcontractors of the latter. After several formal notices remained unsatisfactory, the union took the company to court, arguing that its 2021 Duty of Vigilance plan did not meet the legal requirements set out by the article. In its summons, Sud PTT made general requests to improve the vigilance plan, including risk mapping, supplier evaluation, and the alert and monitoring system, as well as specific requests concerning the prevention of psychosocial risks, the fight against harassment, illegal subcontracting, and undeclared work. The court ruled that the vigilance plan published by La Poste in 2021 was not in compliance with legal requirements due to its lack of precision. It noted several shortcomings. Regarding risk mapping, deemed too general, it did not clearly distinguish between risk level according to activity or geographical location. Regarding subcontractors' assessment procedures, the judge considered that they were not sufficiently focused on the priority risk identified. Regarding the alert and reporting mechanism, the court criticized La Poste for failing to engage in general consultation with trade unions, pointing out that such consultation cannot be limited to simply gathering opinion, but must be the result of genuine dialogue. Regarding the system for monitoring vigilance measures, deemed too incomplete, it did not allow for a concrete assessment of the effectiveness of the measures taken or for reporting on their implementation. However, the union request for the publication of the complete list of subcontractors was rejected, as the court considered that such a measure would undermine business confidentiality and pose practical difficulties. It did, however, reiterate that the internal identification of these actors remained essential. La Poste was therefore ordered to revise and supplement its vigilance plan within a reasonable period of time, without, however, any financial penalty being imposed.
That being said, let's see now why La Poste wanted to appeal. Following the first ruling, La Poste expressed its full adherence to the values promoted by the law and stated it would continue to make every effort to prevent serious violations of human rights, fundamental freedoms, health, safety, and the environment, describing the decision as balanced. A few months later, however, the group appealed, seeking to clarify the interpretation and application of the Duty of Vigilance Law, given the absence of a decree specifying its implementation. In its March 11, 2024 press release, La Poste justified the appeal as necessary for a harmonized reading of the law, particularly if the European Directive on the Duty of Vigilance were not ultimately adopted. It also highlighted the relevance of the new specialized chamber of the Paris Court of Appeal to handle such emerging environmental and social cases. Lastly, La Poste argued that the law remained vague on the plan's format, granting companies some flexibility, especially regarding the implementation report. From now on, let's dig into the analysis of the methodological criticisms upheld by the appeal judges. So following this appeal, on June 17, 2025, the Paris Court of Appeal delivered its ruling, and it marks a jurisprudential turning point. The court not only confirmed La Poste's conviction, but also clarified the methodology required for a compliant vigilance plan. Ruling through its specialized chamber 5-12, the court fully upheld the 2023 judgment of the Paris Judicial Court, while detailing 4 key methodological shortcomings in La Poste's 2021 plan, each corresponding to a stage of the article cited before of the Commercial Court. The first criticism is on risk mapping, which is central to the vigilance plan, and here it's considered too general and lacking in prioritization. The court found that the risks are listed and described in general terms without specifying their degree of seriousness or relevant risk factors, so that no prioritization emerges as required by the Commercial Code. It held that the purpose of mapping is to identify actual and potential risks and to prioritize them by the determining criterion of severity. concluding that the mapping of 2021 Vigilance Plan is characterized by too high a level of generality. The court confirmed that La Poste must highlight the most severe risks through a mapping distinct and independent from the measures implemented, concise, precise, and structured by gravity. The second criticism is on the disconnection between mapping and subcontractor and supply assessment procedures. The court noted that the mapping does not present the specific risk factors or their prioritization, so the plan does not allow for measuring whether the assessment strategy matches the seriousness of the infringements. In practice, La Poste three-steps evaluation process, which is self-assessment, documentary, and on-site audits, showed no clear link to the identified risks. The court reaffirmed that mapping is the cornerstone of the entire system, as it determines the actions to be taken to reduce risks, prevent serious breaches, and ensure monitoring. It therefore upheld the injunction for La Poste to base its evaluation procedures on mapped risks, ensuring full methodological consistency. Then, the third criticism is on the lack of effective consultation on the alert and reporting mechanism. The court recalled that the law requires the alert and reporting mechanism to be established in consultation with representative trade unions. Yet, La Poste has not demonstrated that it engaged in dialogue with the trade unions prior to developing the mechanism. It stressed that the development in consultation differs from simple consultation, as it requires real information sharing and exchange of views before implementation. This clarification establishes that companies must ensure effective and documented dialogue with stakeholders, not merely provide top-down communication. And then finally, the court found that the monitoring system was incomplete and disconnected from the identified risks. It noted that the 2021 plan mainly contained general indicators, such as gender equality or accident rates, but provided no explanations of the implementation and effects of the vigilance measures to identify and prevent serious violations. The court added that the report's content must reflect what is expected of the vigilance plans and be closely linked to the preceding measures. Thus, monitoring must go beyond data. It should measure the real effectiveness of action within the entire vigilance cycle. And so finally, to end this second part and before leaving the floor to Sacha, I want to talk about the solution of the decision. So the court demanding a methodical in its interpretation of the Duty of Vigilance Law and stringent these pillars, rigorous prioritization of risk according to the severity, structural consistency between mapping and evaluation, effective consultation with stakeholders, and last but not least, traceability of monitoring to measure the real effects of the measures.
Now that we have clarified the legal framework and understood how the case was addressed from a legal standpoint, we can move on to the lessons and prospects this decision brings. That the judgment delivered by the Paris Court of Appeal on June 17, 2025 in the La Poste case has a clear pedagogical dimension. It clarifies the level of diligence expected in implementing legal obligation. This decision is the first to rule on the merits on the basis of the law of March 27, 2017 on the duty of vigilance, thus giving this text an effective and no longer just symbolic application. As Garance and Léonore clearly explained, it therefore constitutes a structuring precedent, laying the foundations for demanding interpretation of the law. While companies retain their strategic autonomy, they must now demonstrate methodological rigor, precise traceability, and genuine dialogue with their stakeholders. The decision thus establishes a substantive conception of vigilance policy. The plan must not be limited to a formal checklist, but should become the driver of structural change within the company. The French judge emphasizes the objective of the plan: to identify risks, prevent serious harm, and assess the gravity of potential negative impacts based on specific criteria. This methodological approach shifts the debate from formal compliance to actual effectiveness. By highlighting the need for a hierarchical and reasoned mapping of risk, the Court of Appeal encourages companies to view the plan not as a purely administrative requirement, but as a living tool for risk management and prevention. The decision of June 17, 2025 represents an important step in the interpretation of the 2017 law. The judge no longer limits the analysis to whether a company has a plan, but also evaluates its quality, coherence, and effectiveness in achieving the law's goals. This marks the transition from a purely formal obligation to a concrete and operational concept of duty of vigilance. The ruling emphasizes that the classification of risk must be based on objective and detailed criteria, such as the seriousness of harm, its intensity, and the frequency of exposure. This reasoning aligns French legal precedent with European standards and the UN guiding principles on business and human rights, reinforcing a shared international framework. Moreover, the decision clarifies the role of key actors, workers' representatives who play an active part in alert and reporting mechanism, and judges whose oversight ensures compliance with the legal framework. This dual vigilance prevents the system from being monopolized by company management or compliance experts. Nevertheless, certain limits remain. The ruling still reflects a form of fetishization of the plan. The judge cannot force a company to modify its projects or activities. Indeed, as Garance has already underlined, in this case, the labor union had asked to the court to order La Poste to implement concrete measures to combat harassment, undeclared work, and illegal subcontracting, and the financial penalty in case of delay. However, from the first instance, the French judge refused to require the effective implementation of such measures. As a result, claims based on the 2017 law can only target the plan itself, not the company concrete projects. These compartmentalizations maintain the duty of vigilance within a largely procedural logic, preventing it from becoming fully operational. So, to conclude our presentation, this judgment fits within a broader European movement towards stronger corporate accountability. It follows the adoption of directive known as CS3D to be transposed into French law by 2026. The Paris Court of Appeal explicitly refers to it in line with the European objective and terminology such as, and I quote, adverse impacts. This decision also shows that effective vigilance requires an ongoing cross-departmental process involving CSR, procurement, and compliance team. The practical difficulties of traceability in global supply chains reinforce the need for standardization through sectoral guidelines, reporting standards, and contractual adaptation with suppliers. Finally, this ruling lays the groundwork for harmonization vigilance across Europe and expanding judicial oversight to new sectors such as energy, retail, finance. It also encourages a more collaborative approach between companies, trade unions, and NGOs, turning due diligence into a truly transformative tool rather than a compliance exercise. Thank you very much for your attention. This was our presentation on the La Poste case. You will find our complete bibliography on the final slide. This presentation was presented by Garance MAZARGUIL, Léonore Dubost de Cadalvène, and Sacha BENHAIM-LAFFONT as part of our Business and Human Rights course. Thank you again.